I'm Iris Tao in for Steve Lance tonight. And President Trump's tariffs are back on while his appeal plays out. Our Washington correspondent Luis Martinez has the details, plus how lawmakers are reacting.
There's no question that there's an economic emergency with respect to both uses that we had. One is we are in a world where China has killed over 1 million Americans with fentanyl poison.
The Trump administration defended its use of the International Emergency Economic Powers Act, otherwise known as IEEPA, to impose tariffs on the Chinese Communist Party for its role in the fentanyl crisis. The White House was also critical of U.S. courts it alleges have weaponized the judicial system.
We invoked that rule to stop what has been 20 million illegal aliens streaming into our country, driving down wages, taking jobs away. That's an economic emergency. And on top of that, the world continues to steal about $1 trillion a year as measured by the trade deficit.
Democratic Attorney General of Arizona Chris Mays, who co-led the lawsuit against the Trump administration for its use of IEEPA, celebrated the court's ruling.
Essentially, all of the tariffs that Donald Trump engaged in under IEEPA, basically the April tariffs, are unlawful.
Democrats do not contest that the president has the powers to levy tariffs, but argue that the Liberation Day tariffs need congressional approval.
In its decision, didn't say that the president, whoever the president is, never can levy tariffs under IEEPA. But what the court is saying is the president does not have unbounded authority to levy these tariffs.
The Trump administration has already signaled that it will appeal the court's ruling and request a stay to the tariffs until the appeal is resolved. Democratic lawmakers are pushing for a congressional response to the court's ruling, like Congressman Greg Stanton, who posted on X that this ruling is a major step towards restoring economic sanity and bringing down costs for Arizonans. But the legal fight is far from over. Congress needs to pass my bill to reclaim legislative authority over trade policy. Republicans who control the House and the Senate are unlikely to put Congressman Greg Stanton's bill to a vote. Democrats would have to seek a privileged resolution, which they did attempt in early April and failed to reach the required number of signatures. Reporting from Washington, D.C., Luis Eduardo Martinez, NTD News.
For the White House response to the tariff legal battle, NTD's Washington correspondent Jack Bradley now joins us outside of Pittsburgh, where the president will hold a rally at a U.S. steel plant tomorrow. Jack, good to see you. So let's get into the tariffs. What's the latest on the back and forth here?
That's right, Iris. Well, an appeals court just reinstated hours ago the Trump administration's ability to put tariffs on other countries. Now, that was on April 2nd, where he issued sweeping tariffs on most imports coming into the U.S., about a 10% baseline tariff, with some other tariffs reaching up to 50%. Now, a trade court yesterday ruled that the administration exceeded its authority in issuing these emergency powers. The White House today saying that the lower court's ruling is an example of judicial overreach. Here's the White House's response.
The courts should have no role here. There is a troubling and dangerous trend of unelected judges inserting themselves into the presidential decision-making process. America cannot function if President Trump, or any other president for that matter, has their sensitive diplomatic or trade negotiations railroaded by activist judges.
Leavitt said that the White House is reviewing other avenues to implement Trump's trade policies, and she also mentions that the reason that these tariffs were implemented in the first place was to combat fentanyl coming in from China and also through the U.S.-Mexico border, and also from the Canada border as well as resetting the global trade order, bringing back U.S. manufacturing and resetting those trade deficits that were once existent and rebalancing that. Back to you.
Well, it'll be very interesting to see if other avenues actually would come to fruition as well. And Jack, speaking of which, President Trump is speaking at the U.S. Steel Corporation tomorrow, where you are just outside of Pittsburgh. Tell us more. This is after his approval of a partnership between U.S. Steel and Japan's Nippon Steel. What can we expect?
Well, we can expect a rally. He's talked about a big rally happening tomorrow here, and that's after U.S. Steel and Nippon Steel announced that they'll be merging. Nippon Steel was set to purchase U.S. Steel back in December 2023. And then the President Biden at the time said that this would be a national security concern, losing the ability to manufacture steel here in the U.S. to another country. And President Trump on the campaign trail sided with President Biden on that. But when President Trump took office, he was looking into other avenues that could benefit the American people and ended up with this solution, which would be Nippon Steel, Nippon investing in U.S. Steel, and thereby, he says, creating 14,000 jobs and up to $14 billion in U.S. investment. Back to you, Iris.
And we heard from the White House today that President Trump just this morning spoke with the Japanese leaders. So a lot to see tomorrow when it comes to more details on that deal. Thanks for the update, Jack. Joining us now live to discuss the temporary win for the Trump administration today is Zack Smith. He is the Senior Legal Fellow and Manager of the Supreme Court and Appellate Advocacy Program at the Heritage Foundation. Thank you for coming on.
Of course. Thanks for having me on this evening.
So first, an appeals court has temporarily reinstated Trump's tariffs, pausing a lower court's ruling that had blocked them. What does this case hinge on, and what is the timeline as the Trump administration now is trying to appeal?
Yeah, the core issues in this case hinge on the president's powers under IEPA, the International Emergency Economic Powers Act that we've heard so much about. And essentially what that lower federal court, the Court of International Trade, said is that the tariffs that President Trump imposed exceeded his power under IEPA. Now, I think the president has made some very good arguments that that is not the case. And while this case continues to be litigated, the appellate court, the federal circuit that hears appeals from the Court of International Trade, as you mentioned, has put the lower federal court's order to halt those tariffs. They put that order on hold while this litigation continues. So we'll have to wait and see what happens. But I suspect eventually this issue will ultimately end up before the U.S. Supreme Court.
And that's exactly what the White House is saying as well. And now I want to play you a clip from the White House press secretary from this morning's briefing when she was asked about the tariffs. Watch.
The president's trade policy will continue. We will comply with the court orders, but yes, the president has other legal authorities where he can implement tariffs. However, it does not dispute the fact that the president was right to declare a national emergency when it came to fentanyl and when it came to our crippling deficits and the lack of critical supply chains here at home. That is the reasoning for the president's tariffs. And the
So, Zach, coming back to the question of the president's authority here, talk to us more about any precedents for using emergency powers for tariffs.
So IEPA, the particular law at issue in this case, Congress passed and was signed into law in 1977, but IEPA's predecessor, the Trading with the Enemy Act, dates all the way back to 1917 during World War I, and many presidents have enacted measures under that Trading with the Enemies Act regime that was in place at the time. In fact, Richard Nixon in the early 1970s actually imposed some sanction-like actions against certain other international economic actors that the appellate courts at the time upheld as being within his power under that Trading with the Enemies Act regime. So there is precedent for a president to take action to make sure that American interests are represented in the international economic order. But we'll have to wait and see what the courts do with the specific claims at issue in this case under IEPA.
Well, certainly a lot to watch for in the coming days and weeks here. Meanwhile, in another high-profile case, a judge is temporarily blocking the Trump administration's ban on international students at Harvard. DHS Secretary Kristi Noem says that Harvard is encouraging anti-Semitic violence and coordinating with, quote, CCP officials in training that undermines American national security. So speaking of this legal matter here, does the Trump administration have a case legally based on national security concerns?
Well, Secretary of State Marco Rubio has very eloquently articulated the point that American visitors to the United States, those who seek to visit our country, seek to study here, seek to work here, seek to visit here, cannot take actions that are harmful to the interests of the United States. And essentially, what Secretary Rubio, what DHS Secretary Kristi Noem have said is that unfortunately, some of the students that have been admitted to study at American universities are here causing great harm, advocating for harm either against American citizens or their fellow students. And I think we've unfortunately seen that in many Ivy League schools with the anti-Semitic protests that have taken place at Columbia and Harvard and other institutions of higher learning. And essentially what the administration is saying is that Harvard has not met its obligations under the Student and Exchange Visitor Program. They have not taken sufficient steps to ensure that the students admitted to Harvard under that program are not going to advocate for or act to cause harm to their fellow students or to American citizens. And so I think the administration is right to take a careful look at this program. And I think Secretary Rubio is correct when he says that the United States is under no obligation and in fact should not admit those to our country who seek to do us harm.
Well, certainly, let's see how the court case plays out as Harvard argues on the grounds of First Amendment as well as, a need to ensure what they call diversity on campus. Meanwhile, coming back to this case, what are some of the long-term implications, for example, on visa powers as well as the dynamic between the government and higher education institutions?
Yeah, look, I think we've seen the administration again taking a close look at higher education in general. I don't think it will come as a surprise. Unfortunately, many institutions of higher education have strayed away from their core mission of creating a civil debate, of taking a hard look, examining ideas, and have instead focused more on political activism. Again, we've certainly seen that at Columbia, Harvard, Yale, other Ivy League institutions, but we've seen that at other institutions across the United States as well. And so, once again, this administration is right to take a hard look at and make sure that federal laws are not being violated by these institutions who are benefiting so greatly from federal funds and other federal programs, including the ability to participate in this student and exchange visitor program. And so I say good on the Trump administration for looking at many of these different facets of higher education. And I suspect we'll continue to see more discussion and debate surrounding it as this litigation continues.
Well, certainly sending a strong message to other universities across the country as well. Zack Smith, thank you so much for sharing insights with us today. Appreciate it.
Of course. Thanks for having me on the show.
The Supreme Court today ruling unanimously to narrow environmental reviews for major infrastructure projects. The ruling could potentially speed up approvals of highways, airports, and pipelines across the country. In an 8-0 decision, both liberal and conservative justices voted to limit the scope of the National Environmental Policy Act. It's a law that ensures the government considers the potential environmental impacts before taking on a project. Today's case stems from an 88-mile oil railway project in Utah, which was reviewed and approved by a federal agency back in 2021. Environmental groups brought the approval to court, saying it did not take into account the potential downstream impacts of the project. The review was defended by both the Trump and the Biden administration. Justice Brett Kavanaugh wrote the opinion saying, quote, saying that the NEPA does not allow courts to overstep federal agencies and put constructions in limbo.
Thank you for watching the Capitol Report. If you want to see our full broadcast, check us out at epochtv.com.